case briefs, and so much more. LSData's got what you're looking for.
The Minnesota Court of Appeals, in a 1996 case, State v. Miner, found itself embroiled in a debate over free speech and hunting rights. Jesse Miner and Renee Gardner, the appellants, were charged with multiple violations, including trespassing, disturbing wildlife, and harassing a hunter during a controlled bow hunt at the Murphy-Hanrahan Park. But what sparked a constitutional battleground was the charge that made expressing intent to dissuade hunting illegal. The pair challenged the constitutionality of this charge, asserting it infringed on their First Amendment rights. The court agreed with the appellants to a significant extent, declaring that hunting discouragement through speech could not be penalized. This defanged aspect of the statute, Min. Section 97A037, was ruled unconstitutional. The court then revised the statute, making it enforceable only when someone disruptively interferes with another person lawfully hunting or preparing to hunt a wild animal. In short, it had honed the statute, which was intended to protect hunters, to only apply to those physically disrupting the practice of hunting, not just speaking out against it. Despite this revision in Miner and Gardner's favor, the court dismissed their argument that the modified statute still infringed on their First Amendment rights. They argued that they had only intended to express their opposition against hunting. However, the court deemed their actions to have purposefully interfered with lawful hunting. The crux of their convictions lay with their actions that day in the park: blatant trespassing, disturbing wildlife, and harassing a hunter. These offenses, the court argued, had little to do with their free speech, but more so with their conduct. Hence, the modified statute was found not to be unconstitutional as applied to them, and their convictions were upheld. In the grand scheme of legislative interventions, the court ruled that Min. Section 97A037 served an important governmental interest, regulating wildlife conservation and safeguarding individuals' right to hunt. They deemed that these protections were not designed to suppress free speech, but rather to address conduct that actively disrupted hunting. The statute, thus amended, was charged to be neither unconstitutionally overbroad nor vague, and didn't impose an invalid restriction on time, place, and manner of protected expression.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.